Examining trials, to get a little technical with it, it's in the Texas Code of Criminal Procedure, specifically Chapter 16. And that's what we deal with. What it basically is it's a hearing that the defense and prosecution have before a judge or a magistrate, and it's there to determine a couple of things. One, is there probable cause to continue detaining the person? And is bail sufficient to detain them if there is probable cause? Okay. Generally speaking, I've been practicing for 12 years. I've only filed for an examining trial, I believe, twice, maybe three times, and there's a couple of reasons for that. Number one is that if a person is indicted, then all right to an examining trial is ended. An indictment, for lack of a better word, cures any concerns that you would have that would otherwise come out during an examining trial. Indictment, well, maybe not obviously, but with an indictment, it goes to a group called a grand jury. Grand jury is a group of people, usually 12, that meet for about a month at a time, and they hear cases completely unilaterally. That means that it's just the prosecution presenting it. It's not even prosecution and defense. So in my personal experience, and again, the two or three times I've actually filed for one case, the state just dumped it. They dismissed it and said, yeah, we're not going to bother with this. And the other one or two, it got indicted by a grand jury almost immediately. And then once you're indicted, there is no real right to have an examining trial. As for reasons why somebody would want one, a lot of it, in my opinion, would come down to trial strategy, among other stuff. Right now, you have somebody that's detained, and Brad Simpson, I'm sure he has a bail or bond that's been set as he's entitled to by law, and presumably a very, very high amount. It wouldn't surprise me in this case if it's $1 million or more between all the cases. If they are able to get an examining trial and a magistrate's able to look at the evidence and saying, hey, this is pretty weak, there's not enough really here to hold him, then it could result in a bond reduction, which or in his immediate release, which would, in my estimation, would be what they're trying to go for. Another thing also is if you do go through an examining trial, you kind of get to see a little bit of the state's hand. They have to present evidence. Now, with discovery and disclosures, the defense is going to be provided everything in there: reports, police officers, statements, testimony, and everything else, but sometimes it helps to see what they're thinking, how they present it as well. I'll also say that examining trial, all the regular rules and procedures for a normal trial would apply. It's not like it's abbreviated where they relax the rules. Again, like a grand jury, rules are greatly relaxed. Hearsay's allowed. It's much, much easier to present a case when you're not necessarily burdened by all those. Let's see here. As far as else, what other questions did you have, ma'am? Oh, you're muted.
So is this something that you would see more commonly from a defense or a prosecution, or is it just a tool that both sides use?
It's going to be exclusively for the defense, and again, because the defendant is going to be the one that's deprived of liberty and everything else. I Off the top of my head, I don't think the state can even request an examining trial. Again, what the state would do is they would present their case to the grand jury and have an indictment issued. And again, once that indictment comes down, it cures any concerns or defects with an examining trial. Even if it's on file, you're scheduled, you're on the calendar for the court. Once there's an indictment issued, it's over. The settings dropped as basically being moot, and you proceed forward from there. But yeah, this is unilaterally a defensive strategy to move forward. And again, the main goal is to get somebody out of custody. Collaterally, you can also, like I said, you get a little peek at the state's hand, maybe get an idea of what they're thinking, but the 99% of it's going to be you're trying to get somebody home.
Now, just because the defense has motioned for this examining trial, that doesn't necessarily mean it's set in stone. What does the process of that look like?
Yes, so you have a right to it, and so there will be an examining trial set. There's also a few other deadlines that kind of run concurrently with that. Anytime once you're incarcerated in the state of Texas under Chapter 17.151, The state has a timer to get you indicted. We're just talking felonies, and that timeline is 90 days for anything other than a capital murder. Okay, so in this case, we're just dealing with murder. It's a first degree felony. So the state just can't sit on their hands and do nothing. Once they arrest you, the clock starts ticking. Now they have 3 months, and that's a long time. But if that 90 days comes up and it's day 91, the law is very unforgiving. You're either going to be cut loose on a personal recognizance bond, a PR bond, or your bond is going to be lowered so severely that you have to post it. I've seen it where on a murder personal case of mine, the murder bond went down from I think 300,000 down to $5,000. Simply because that's all they could afford. But again, once they miss that 90-day deadline after somebody's detained, you have to cut them loose.
So, for someone like myself who had never heard of an examining trial before today, what difference, if any, is there from an examining trial and an evidentiary hearing?
Um, Rephrase that. I'm sorry. Say it again.
So, okay, I come from Oklahoma where there are evidentiary hearings. And from my understanding, it sounds like it's similar to an examining trial, but is that similar, different?
Um, I'm trying to think what we would have that's the it would be similar. I mean, in its basic term, it is an evidentiary hearing, right? Because they have to present some kind of evidence, even if it is just testimony. And testimony is evidence. It's one of the number one things we have to remind juries of. In fact, it's probably the most common type of evidence is simply people talking, relaying what they know or what they saw or what they did. So yes, it is an evidentiary hearing. And again, the burden of proof, my apologies, the rules of evidence do apply the same as it would be for a jury trial. So you're going to call people, you still have the right to make objections to hearsay. You have to do what we call laying predicate, like to preempt. You can't just throw reports in and get them in there. You have to lay some kind of groundwork and everything else like that. So yes, it is very much an evidentiary hearing, and the rules really aren't that relaxed as opposed to if this was a trial hearing or motion to suppress or anything else like that. So if you want to know, actually, I just looked it up. Article 1607. It's the same rules of evidence as on final trial. Same rules of evidence shall apply to and govern trial before an examining court that apply to govern a final trial. So right there from the Code of Criminal Procedure, very much like an evidentiary hearing, as you would call it, or just any kind of contested hearing that you would have. You still have to comply with all the rules.
And just to be perfectly clear from my understanding, so does this trial, does it mean that Brad could possibly get sent home or his not charges thrown out?
It could, yes, it could result that he gets thrown home, that he gets sent home. The judge says, "Hey, there's not enough here to hold him." Now, it doesn't mean the case necessarily goes away. Anyone that's done felony work for a long time, you see this sometimes where sometimes even on their own accord, the state will dismiss it without an examining trial. They realize they just don't have enough evidence. However, you have statute of limitations, which on a murder is unlimited. You can file a murder charge at any time. And if new evidence comes forward, the case gets stronger. If it is thrown out, they could absolutely be recharged again. So this is, in my estimation, it's something to kind of force the state's hand because you have somebody who's obviously in custody that's not able to get out. And I would anticipate that is their primary goal. They want him to go home, even if it is a temporary release.
So even if the state is able to provide like a handful of evidence that proves that they have enough to keep Brad, what happens that he just stays until an actual trial starts?
Yes. So there's a couple of things that would have to happen. Again, they still have to get him indicted within 90 days. So let's say the judge says, I'll give you an example. The judge could say, yes, there's more than enough probable cause here. And in fact, I think your bond is insufficient. I'm going to raise it to $2 million or whatever it might be. Again, if the state doesn't get him indicted, which is with a grand jury, a little bit different process, and they have 90 days to do that from the date that he was arrested and charged, then he gets another shot at getting to go home possibly. Again, this is a very temporary deal. It wouldn't surprise me if the state seeks an indictment before the examining trial actually happens. In my experience, that's what often happens. And again, there is an indictment that comes down. All this is just academic and moot. There's just there's absolutely no relief that will come from the examining trial.
So the defense is really racing against the 90-day timeline and hoping that an indictment doesn't come down before that trial happens.
Absolutely, yes. Now, I will say this too, on the 90-day timeline, if you make bail or bond, you're able to get out of custody, then it doesn't have as much importance. That's simply to release somebody if they're still held in custody after 90 days. And that applies to any felony, as low as a state jail, like a simple drug offense, all the way up to murder.